And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Supreme Court just dropped a unanimous 9-0 decision that is sending shockwaves through every single state in America. This isn't just another ruling, it's a complete reset. It changes everything about how gun rights, lawsuits, and government overreach will be handled from this moment forward. Overnight, the legal ground under the Second Amendment has shifted. What happens next is going to affect every gun owner, every manufacturer, and every American who values constitutional freedom. If you care about your rights, you need to hit that subscribe button right now. Because what I'm about to show you changes the game entirely. The case we're talking about is Smith and Wesson versus Mexico, and it's the most important gun rights victory you probably haven't heard enough about. Here's the deal. The Supreme Court didn't just side with American gun makers, they slammed the door on a whole new type of legal warfare. Mexico tried to file a $10 billion lawsuit, claiming that American companies were responsible for cartel violence because their firearms were being smuggled across the border. The court didn't just reject this claim, they destroyed it, unanimously. Every single justice, from the most conservative to the most progressive, agreed that allowing this lawsuit would violate American sovereignty. They made it clear that the criminal misuse of a legal product does not make the manufacturer liable. This is now binding precedent in every federal court in the country. But here's what most people are missing. The real power of this ruling isn't just about what the court said, it's about what they refused to allow. They just dismantled the #1 strategy activists have been using to attack your rights for the last 20 years. For decades, a law called the Protection of Lawful Commerce in Arms Act, or PLCAA, has been the primary target of anti-gun groups. This law was built specifically to stop people from trying to bankrupt gun companies through endless, frivolous lawsuits. Before this law existed, activist groups would sue gun makers not because they expected to win, but because they knew the legal fees alone would destroy the industry. This 9-0 decision just gave that law the strongest armor it's ever had. The court made it absolutely clear. This protection is constitutional, it applies broadly, and no foreign government or creative legal theory can bypass it. This is no longer a partisan issue, it is settled constitutional law. But here's where it gets really interesting. This ruling just found its perfect partner in the Bruen standard. You might remember that 2 years ago, the Supreme Court established that any gun restriction must be consistent with America's historical tradition. If a law doesn't have a clear historical analog from the founding era, it's unconstitutional. Period. Now, these two rulings work together like a double-layered shield. Bruen tells the government they can't ban your rights directly, and this New Mexico ruling tells them they can't ban your rights indirectly by suing manufacturers out of existence. Together, they make it exponentially harder for gun control advocates to use the legal system as a weapon. In fact, multiple federal judges are already citing both of these cases together in their opinions. And you know what's in the immediate line of fire? Assault weapon bans. 7 states currently have these bans on the books, and they are all facing a massive constitutional crisis. States like Illinois, California, and New York ban rifles based on cosmetic features, like pistol grips or adjustable stocks. But the ground is crumbling beneath them. The AR-15 is the most popular rifle in America, with over 20 million in civilian hands. It's a common arm, and under the Supreme Court's precedent, common arms are explicitly protected. This new ruling makes it even harder for states to argue that these rifles are dangerous because of how they're marketed or misused by criminals. The dominoes are already starting to fall. We're seeing federal judges issue injunctions against these bans, citing both history and this new protection for manufacturers. But it's not just the rifles. Magazine capacity limits are facing the same fate. 10-round limits exist in 9 states, but there is zero historical precedent for them in American history. If manufacturers can't be held liable for the criminal misuse of a standard firearm, they definitely can't be held liable for the capacity of a standard magazine. Even concealed carry restrictions are under new pressure. Since the Bruen decision, several blue states responded by declaring almost everywhere a sensitive place where carry is banned. Times Square, parks, even restaurants. But this unanimous ruling weakens their defense. It establishes that lawful commerce in arms is a protected activity, and fear of social costs or liability cannot be used as an excuse to restrict a constitutional right. We're even seeing waiting periods and one-gun-a-month limits in danger. These are modern inventions with no roots in the founding era. For most of our history, you could buy a firearm and walk out with it immediately. Now that the court has ruled that manufacturers aren't responsible for what a criminal might do, the government is finding it impossible to justify restricting when and how much a law-abiding citizen can buy. And finally, we have to talk about red flag laws. 21 states currently allow firearms to be confiscated based on allegations, often without the gun owner even being present to defend themselves. But the constitutional framework just shifted. This new ruling emphasizes that lawful ownership is a protected activity that can't be restricted based on speculation or what-if scenarios. If you can't sue a manufacturer for what a criminal might do, you can't take away a citizen's rights based on a prediction of what they might do. This 9-0 decision has changed the game for every single gun rights battle happening in America right now. The next 6 months are going to determine which states back down and which ones try to double down on unconstitutional laws. If you want to stay ahead of every ruling and every move that affects your Second Amendment rights, you need to subscribe and hit that notification bell. This fight is just getting started. Drop a comment below and tell me, which state restriction do you think is going to fall next? I'll see you in the next one.